Oh, morning, everybody. Excuse me. Good morning, everyone. My name is Jeffrey Salant. I am the HOA Information Officer for the Division of Real Estate, which is a division of the Colorado Department of Regulatory Agencies, also known as DORA. This morning, we are going to talk about the annual disclosures which your association is required to make, as well as record requests, including what type of records you are entitled to, which records you may not be entitled to, and the process for making those requests. There are two handouts attached to this webinar, a PDF copy of this presentation, and a copy of the Colorado Common Interest Ownership Act. You may download these handouts at any time by clicking on the blue links located under the Handouts tab on the GoToWebinar control panel. In case you are unfamiliar, this is what the GoToWebinar control panel looks like. The highlighted section shows you where you may access the links for today's handouts. If you have any trouble accessing the handouts, please contact me after the webinar for copies. Please note that the information provided during this presentation is for educational purposes only and not meant to provide or be construed as legal advice. Any legal questions should be directed to your attorney. Before we get into the presentation topics, I want to take a moment to talk with you about my office, the HOA Information and Resource Center. The HOA Center is a statutorily created office, and my position, the HOA Information Officer, is appointed by the Director of the Division of Real Estate. Per statute, the HOA Center provides information to homeowners regarding their basic rights and responsibilities under Kiowa. It gathers and analyzes and reports information through complaints and HOA registrations and writes an annual report. It creates resource materials, provides education, and presents HOA forums such as this one. We maintain a website with information for the public, and we also register HOAs. As for what my office does not do, the HOA office is not a regulatory program. We are not able to mediate or arbitrate. We cannot provide legal advice. We do not act as an advocate. We cannot assess fines or penalties, and we do not enforce an HOA's failure to register. So in Colorado, HOAs, or common interest communities as they're formally referred to, are governed by the Colorado Common Interest Ownership Act, colloquially referred to by its initials, CCIOA or Kiowa. This statute defines the rights of unit owners as well as those bestowed upon the association. It also defines the responsibility of an association as directed by its executive board. Kiowa provides for the enforcement of those rights and responsibilities through civil litigation. Unfortunately, the state has no authority to intervene in any association member's conflict with their association, nor does it have any jurisdiction to enforce the rights and responsibilities defined in Kiowa. Succinctly speaking, there is no regulatory oversight of HOAs in the state of Colorado. Any dispute between homeowners or homeowners and an HOA is considered a civil matter. So the main source of authority describing an association's responsibilities with regard to disclosures is going to be section 38-33.3-209.4 of Kiowa. This section creates standards for the disclosure of certain information by the association, in addition to specifying the time frame in which the association must release certain information after assuming control from the declarant. It also specifies a time frame in which the association must release certain information after the end of each fiscal year thereafter. After assuming control from the declarant, the association must make the following information available to homeowners within 90 days: the name of the association, the name of the association's designated agent or management company, if any, a valid physical address and telephone number for both the association and the designated agent or management company, if any, the name of the common interest community, the initial date of recording of the declaration, and the reception number or book and page for the main document that constitutes the declaration, which should be on file with the clerk and recorder in the county in which the HOA sits. In addition to the records identified in the previous slide, an association must also make the following information available within 90 days of assuming control from the declarant, as well as within 90 days after the end of each fiscal year thereafter: the date on which the fiscal year commences, the operating budget for the current fiscal year, a list by unit type of the association's current assessments, including both regular and special assessments assessed as of the date of the disclosure, its annual financial statements, including any amounts held in reserve for the fiscal year immediately preceding the current annual disclosure, the results of the most recently available financial audit or review, if any, because keep in mind, Kiowa does not require audits, but your governing documents may, a list of all insurance policies, including but not limited to property, general liability, association, director and officer professional liability, and fidelity policies, keeping in mind that this information should include the insurance company names, policy limits, policy deductibles, additional named insured, and expiration dates of the policies listed. All of the association's governing documents, including its bylaws, articles, and rules and regulations, all meeting minutes of the executive board and member meetings for the fiscal year immediately preceding the current annual disclosure, and the association's responsible governance policies. When Kiowa was drafted, we know it was the drafter's intent to allow the association a wide latitude in the methods and means of disclosing this information, while requiring that the information be readily available at no cost to unit owners and at their convenience. As such, an association may accomplish the required disclosures by any one of the following means: posting an internet web page with accompanying notice of the web address via first-class mail or email, the maintenance of a literature table or binder at the association's principal place of business, or mail or personal delivery. While an association may charge a reasonable fee in connection with a related record request outside of the annual disclosure, and we'll talk about that more in a minute, the cost of the distribution of the annual disclosures must be accounted for as a common expense liability. So outside of the annual disclosure, an association is required to maintain certain records specifically for the purposes of record retention and production to owners. Section 38-33.3-317 of Kiowa discusses this requirement, including which records must be maintained, which records must be provided to owners upon request, which records may be withheld, which records must be withheld, and the timing and costs associated with record requests. In summary, most association records may be divided into three categories: those records which must be provided when properly requested, records which may be withheld, and that's subject to the discretion of the board, and those records which must be withheld. The requirements in this section are in addition to any records that are specifically defined in the association's declaration or bylaws, or expressly required by section 38-33.3-209.4, which we just spoke about regarding annual disclosures. So be sure to check your governing documents for any records that may not be mentioned in section 317, but which you are entitled to by virtue of that language within your governing documents. Okay, so the following records must be provided when they are properly requested. They include items such as detailed records and receipts and expenditures affecting the operation and administration of the association, keeping in mind that the association is in no way obligated to compile information. What that means is if you're looking for, let's say, you request how much did the association spend on landscaping in the last fiscal year, all they have to do is provide you with detailed records of receipts and expenditures affecting the operation and administration of the association. And then it's up to you to go through that information and identify the relevant data to your inquiry, and then for you to do the math to determine the answer to your question. This section also includes minutes of all meetings of its owners and board, a record of all action taken by the owners or board without a meeting, a record of all actions taken by any committee of the board, a list of all the names of all owners and the physical mailing addresses at which the association communicates with them, as well as showing the number of votes each owner is entitled to vote, and financial statements for the past 3 years, as well as tax returns of the association for the past 7 years. Note that there is a common misconception when it comes to membership lists. You may note that I just mentioned that you're only entitled to a list of unit owners, their names, and their physical mailing addresses. Contrary to common misconception, you are actually not entitled to the email addresses or the phone numbers of other members of the association. In continuing the must provide category of records, we also have items such as the current reserve study, if any, because again, Kiowa does not require a reserve study, but your governing documents may. This section also includes current written contracts to which the association is a party and contracts for work performed within the last 2 years, ballots, proxies, and other records relating to voting by owners for 1 year after the election, action, or vote to which they relate, and a list of the names, email addresses, and physical mailing addresses of the current board members and officers, keeping in mind that the board is allowed to designate their own email address. Therefore, if they choose to use the email address of the community association manager, they may do so. Similar to the requirements for a membership list, the list of board members does not need to include and should not include phone numbers. However, as earlier discussed, the annual disclosures do require that a phone number for the association or the community association manager, if there is one, be included with those annual disclosures. The next category of records is may withhold. And again, this is in the discretion of the board. The following records may be withheld, again, at the discretion of the board. And Kiowa does not provide any means for challenging a board's decision regarding this category of records outside of litigation. They include items such as architectural drawings, plans, and designs, unless released upon the written consent of the legal owner of such drawings or designs. Contracts, leases, bids, or records related to transactions to either purchase or provide goods or services that are currently in or under negotiations, noting that whether or not negotiations are taking place is a determination that is going to be made by the board. Communications with legal counsel that are otherwise protected by attorney-client privilege or the attorney work product doctrine, as well as records of an executive session of the board and records relating to or concerning individual units other than those of the requesting owner. This means while you are entitled to detailed information regarding your association account, you're not entitled to that same information regarding your neighbor's unit, unless for some reason the board, in their discretion, decides to release that information. And the following records must be withheld by the executive board, and they do not have any discretion with regard to their release. They include items such as personnel, salary, or medical records relating to specific individuals, or personal identification and account information of members, including bank account information, telephone numbers, email addresses, driver's license numbers, and social security numbers. So although entitled to certain records, homeowners must still be sure to request those records in the appropriate and proper manner. While Kiowa does not spell out that process, it does require associations to adopt policies, procedures, and rules and regulations concerning the inspection and copying of association records by unit owners. Homeowners should review their association's record request policy when requesting records. All records maintained by an association for the purposes of document retention and production to owners must be available for examination and copying by a unit owner or the unit owner's authorized agent. However, an association may require unit owners to submit a written request describing with reasonable particularity the records sought at least 10 days prior to inspection or production of the documents, and may limit examination and copying to normal business hours or the next regularly scheduled executive board meeting if the meeting occurs within 30 days after the request. If you follow the appropriate procedure for requesting records that you are entitled to, and the board does not provide them within 10 days after the request, and there is no scheduled board meeting within 30 days after the request in which the records are provided, then you will have to engage your board in either alternative dispute resolution, such as mediation or arbitration, or as a last resort, you may have to consult with an attorney about your rights in civil court. Now, some of you may heard that during this year's legislative session, House Bill 21-1229 amended Kiowa to create a presumption of damages in the amount of $50 per day for failing to produce documents within 30 days upon request. Since this language only recently became effective, and I believe this was yesterday that the law took effect, we don't really have any examples of how these damages may be awarded, but we can say for certain that they are not automatic. Similarly to all other provisions in Kiowa, your first step in securing any right provided to you is to assert that right to your association. And now this could be as simple as writing your association a letter, describing the circumstances of your dispute, addressing the relevant language in either Kiowa or your governing documents that support your position, and then asking for a resolution. If you've already tried this approach, or you try it and you are unsuccessful, you will likely have to engage in alternative dispute resolution or possibly engage in civil litigation in order to secure your right for such presumptive damages as provided by the newly amended Kiowa language. Unfortunately, that is the limit of information I can provide on this new bill. If you have any additional questions regarding this new bill and the $50 per day punitive damages, please do reach out to a qualified, licensed community association attorney here in Colorado for more help. An association may impose a reasonable charge, which may be collected in advance, and it may cover the costs of labor and material for copies of association records. The charge should not exceed the estimated cost of production and reproduction of the records. If your association employs a community association manager, they may collect the fee on behalf of the association, or they may charge it directly. If they will be collecting the fee directly, it should be listed in their management agreement. Any dispute as to the reasonableness of the charge will have to be determined by a court, and an association may deny a record request if the requester did not follow the association's policy on record requests or if the requester refuses to pay the required fee. A membership list may not be obtained or used by any person for any purpose unrelated to a unit owner's interest as a unit owner without the consent of the executive board. Without board consent, a membership list may not be used to solicit money or property unless such money or property will be used solely to solicit the votes of unit owners in an association election. It may not be used for any commercial purpose, and it may not be sold to or purchased by any person. Despite any provision of the declaration, bylaws, articles, or rules and regulations of the association to the contrary, the association may not condition the production of records upon the statement of a proper purpose. What that means is, so long as you are properly requesting records in accordance with your association's record request policy, those records fall under the category of must produce, and you wait the allotted time, the association may not prevent you from obtaining those records because you have not stated a proper purpose for them. There is no need for any proper purpose for records which you are entitled to. When it comes to best practices for associations handling record requests, transparency is key. Once a record request has been properly made, the board should use Kiowa as a guide when fulfilling that request. The main information that should be considered when fielding a request is the information in 38-33.3-317. No record request should be denied because the board or a board member believes the request was made either in bad faith or because the requester does not have a, quote, proper purpose for the records. The HOA Center frequently hears from homeowners who believe that their record request is not being fulfilled because they've had some recent disputes with the board. Likewise, we often hear from board members who are skeptical of certain record requests because they come from homeowners that the board may consider, quote, troublemakers, and because the requests are reviewed as nuisance requests. Regardless of the personality conflicts involved, properly submitted record requests should always be treated as a legal requirement, and every attempt should be made to accommodate them. Board members are intended to be stewards, not gatekeepers. Another complaint that we hear a lot is that the fee an association or their management company is charging is not reasonable. Again, while any dispute as to the reasonableness of the charge will have to be determined by a court, there may be some things that an association can do to limit or reduce any fee associated with record requests. If your association employs a community association manager, consider asking them during negotiations to rearrange their fees so that there is little to no charge for record requests. But do keep in mind that this may raise other costs, such as administrative fees or your monthly management fee. These fees that community association managers charge for record requests are usually defended with a statement that such charges are individual to the unit owner who is requesting that those records. Therefore, they should be the ones to shoulder any costs, as well as a statement in defense that these charges will help to lower the overall management fees that are charged to the association. Ultimately, it is the decision of the board when it comes to accepting or not accepting these fees. But a lot of management companies will make that part of their management contract. And if the association is unwilling to accept those charges, then they may not be able to obtain those management services. Additionally, an association may make regularly requested documents readily available via a website or a binder in the association's place of business. This could help alleviate any necessity to charge for labor in connection with a record request for those frequently requested documents. And finally, when in doubt, seek legal counsel. A lot of times boards will avoid reaching out to legal counsel because of the fees associated with that. I certainly understand that. But if you genuinely believe that there is a discrepancy or extenuating circumstances behind the provision of certain records that Kiowa does not make clear, it is incumbent upon you to ensure that you are following the law and protecting both the association and the homeowners. And when it comes to best practices for homeowners, the best advice I can give is to be patient. Yes, your association is a business and it should conduct itself as such. However, we all should know that in practice, many associations simply do not have the internal infrastructure to immediately comply with every single request that it receives. Specifically, most self-managed associations do not have the ability to react immediately or even quickly. Board members in a self-managed community may have full-time jobs and will only be available to review and accommodate requests on nights and weekends. Furthermore, unless your association has a central office with a physical filing cabinet system, the records that you're looking for may be in a box in one of your board members' garages. It's going to take some time to locate and duplicate records housed in this way. Even if your association is professionally managed, managers will still need to prioritize resources. Being reasonable with your expectations of how quickly you will receive the records requested can help you avoid potential disputes arising from that request. As discussed, the association may, and in most cases, will charge for record requests. Understand that this is not intended to be a deterrent, but rather enables associations to avoid unexpected costs associated with large record requests. Arguing about the fee is not going to help you get your records any sooner. Remember, if you feel strongly that your association or management company is charging an unreasonable fee for record requests, your only option is to pursue alternative dispute resolution, which is voluntary. So if your association is not willing to engage in alternative dispute resolution, such as mediation, then your only other option to pursue your assertion that the fee is unreasonable is to litigate on the matter. If you are unwilling or unable to pursue either of those options, you should strongly consider alternative methods of obtaining the records you're seeking. Your county's clerk and recorder is a good place to find your association declaration, which must be recorded with them. And although HOAs are not required to record other governing documents, some do. So that's always a good place to start.